Welcome to Employee Benefit Plans and Business Sense.
Hey everybody, welcome to an all-new episode of Employee Benefit Plans and Business Sense with Lank and Kathleen that you see here pictured from KLB Benefits Law Group. I'm your host, Mike Leon. You know, Lank and Kathleen, they help employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. And they've got decades of combined experience in employee benefits law, and they partner with other attorneys to protect clients from costly mistakes to resolve those benefit issues efficiently. In today's episode, we're talking about how employment lawyers should know about benefit law and how partnering with an employee's benefit attorney can protect your rights and strengthen your cases. So, Dal, I'm going to start with you on this one. What is the difference for the folks watching this and listening to this? What is the difference between an employment lawyer, and an employee benefits lawyer? And is there an overlap between the two?
Yeah, there's actually not much overlap, really. The common denominator is the employee, a company with employees. Employment lawyers deal with state law issues or federal civil rights issues, and the employee benefits lawyers deal with a very narrow subset of a federal tax law and other federal law that governs really the tax qualification rules and the features of ERISA covered retirement plans, ERISA plans such as retirement plans and health and welfare plans, for example, medical insurance plans. So benefits law, what we do is much narrower in scope generally than what an employment lawyer does. And employment lawyers, if they deal with federal law, it's in the connection with federal civil rights law, but they deal, I'm sure, primarily in state law in connection with employees' rights and what it means to have employees in a company. So what an employment lawyer, really somebody looking for an employment lawyer may call an employee benefits lawyer, not realizing that there is this difference when, they might have a claim about their employment contract, and we don't deal with that. But whereas if they are calling an employee benefits with an employee benefits question and they call an employment lawyer, the employment lawyer might say, "What now? What is ERISA?" They might not even be very familiar with ERISA. So really, there's not much overlap.
I would just say, the sort of where the combined experience might come into contact, in that sense, overlapping is in a leave of absence situation. A lot of times, those are the employment lawyer is going to be working with sort of the leave of absence requirements, which are, governed by state and federal law. But there are benefits issues in a leave of absence that they're not going to have the expertise. They might have some knowledge, but they're not going to have the depth of understanding of benefits law to address that. And that's where we come in. And also when an employment lawyer is frequently working with terminations and bigger layoffs, and the same thing it happens is that, that's where there are going to be benefits issues raised by these bigger employment events. And, just sort of something we talked about on one of our last podcasts is the complexity of employee benefits law sort of makes it unfeasible for an employment lawyer to kind of have the full breadth of knowledge. So they don't, that's what employee benefits attorneys do.
Well, let's stay on that because I would love for you guys to drill, and Dal, you can take this one, drill a little bit more into the specificities of what benefit law. We just mentioned a few, we touched on it, but what are some actual benefit law issues that would surface for an employment lawyer?
Well, if an employee wants to file a complaint or has a complaint that gets to the level where they're consulting with an employment attorney to sue their company, for example, if they have issues in connection with denial of their benefits under a plan, under an ERISA plan, that there's a different procedure. There's usually a different procedure for under ERISA, under our area of law, for denial of benefits or mishandling of a claim under a plan than there would be compared with other employment law issues. So they go to an attorney, say an employment attorney who's a litigator, and say, I want to sue my company. They've done 10 things wrong, and 8 of those things are in connection with their employment contract, or the timing of their pay, or the amount of their pay, or whether they've been discriminated against in connection with their age or other protected class. 8 of those things might have to do with the employment lawyer's area of expertise. And then the other 2 things out of the 10 may have to do with the denial of benefits claims for their retirement plan or their health insurance plan, for example. And then the litigator, the employment attorney, probably won't know the technical details of what exactly the claims what they could get from the employer, or what the claims might actually be for those 2 benefits issues. That's when an employment attorney might pick up the phone and call a benefits attorney.
Yeah, and just to add on to that, in general, for example, Dahl and I don't do litigation. We generally represent the employers. So it's important to find the right employee benefits attorney. I would say, when there's sort of like a wrongful termination situation, benefits issues are often sort of tacked on to the lawsuit. For example, COBRA, it's like it may not be worth it for an former employee to sue on a COBRA issue. Maybe they are saying they didn't get their COBRA notice, or, they weren't offered COBRA. But what happens often in a litigation situation is that they'll just sort of add that into the bucket of claims. And then whereas the employment lawyer who is doing the litigation, basically defending the case for the employer, they're going to probably need some employee benefits expertise to deal with those claims. Also, the kinds of things that we deal with that come up for employment attorneys are things like when there are layoffs. There are if there's a significant layoff, then that can trigger some requirements in their retirement plan. If there's a significant layoff, then that's considered a partial termination, and which triggers certain vesting of benefits. It accelerates it for participants, and that's something that can get ignored in a large termination situation. And that's not something that's within an employment attorney's bailiwick. It's something that the plan would need to be, basically corrected for a partial termination if a significant enough number of employees are laid off, or specifically participants. And we also come into, things like employment handbooks, which is something employment attorneys work on all the time. That booklet that new employees get, and the sort of the way we can help is there's almost always a benefits section in those employment handbooks. And I will tell you, when I have looked at those, I often find they don't match up with what the actual benefits are. And they may overpromise benefits, which creates inadvertent, vesting. And so it's always a good idea for an employment attorney to know an employee benefits attorney that they can have review that section of the employment handbook. So that's just some examples.
Yeah, no, and I'm glad you gave those examples. And I want to go back to something you said, Kathleen, and Dal, you can answer this one if you want. It was about a lawsuit, a potential lawsuit, and there's still like an unresolved benefit plan issue. You mentioned COBRA. There could be some other examples. But for you, how can leaving this benefit plan issue unresolved, like, does it affect the outcome of that lawsuit or even a workplace dispute that they're having with the employer?
Everything that affects the outcome of the lawsuit is up to the 2 parties in the lawsuit to know what the law is and to apply it correctly in the lawsuit. So a lot of it depends on the quality of the representation on either side of the lawsuit. But if you leave a benefit issue unresolved in any context, it only will get worse money wise. It'll only become more expensive to correct, and a bigger problem, and probably a bigger employee relations problem, not to mention a lawsuit issue. the longer it sits. So there is no statute of limitations. There is no statute of limitations on a plan failure or prohibited transaction until, in the case of a tax qualification failure of a plan, which may or may not actually affect an employment litigation, but there's no statute of limitations on a plan failure until the plan is terminated, and then the statute starts running, and the plan has to be terminated. That's after that's in the future usually, and that's a 3-year statute generally, following termination of the plan and final distribution of its assets. And there's no statute of limitations on a prohibited transaction in a plan until that prohibited transaction is reported and tax is paid. So the government, the law is set up, the federal law that governs retirement plans and ERISA plans is set up to incentivize employers to find and correct mistakes soon and promptly and fully. And so in the context of litigation in an employment law situation, there could, if the attorney representing the plaintiff or the plaintiff becomes aware of facts that are connected with plan failures or prohibited transactions, those can really be powerful tools in the hands of the plaintiff against the company that's sponsoring these plans. And so it really benefits the company to find and address problems early, as soon as possible. And obviously it varies with the facts and circumstances of any particular case, but we can definitely, benefits attorney can definitely help reduce the cost of litigation.
Yeah, and also I would say in a litigation situation where, again, I'll use the COBRA example because that's, as I said, that's often just sort of tossed into a bigger, meatier sort of claim. Yes, a lot of times it's, something that we can help defend, find facts, ask the right questions, and be able to sort of say, hey, maybe you didn't get your COBRA notice, but the employer did everything they were supposed to get it to you. And we have some proof of that. And that there are certain situations, for example, with COBRA that can be a good defense, that it wouldn't be like a typical, defense in a wrongful termination situation. It's a benefit specific issue. So there are benefit specific defenses and remedies and all of that.
So staying on that, Dal, can you share a case, because we've been kind of dancing around and differentiating between the employment lawyer and the benefits attorney. Can you give us an example? Maybe you have one recent, way back. Share a case where an employment lawyer brought you guys in, and what did it do for the client? Did it change the outcome for the client?
Well, we helped avoid a big mistake once. Very, very recently, actually, litigation was happening in a company where part of the company, there was company stock in the plan, in a retirement plan, owned by a couple of employees. Employee was terminated, he believed wrongfully. It commenced, his alleged wrongful termination triggered something like 6 years of litigation or something like that in between this former employee and the company. And the former employee had some stock of the company in his retirement plan, and wanting to settle the case and part ways after lots of fighting, they tried to have the court approve their litigation settlement, which contained a term that provided for the plan to be cashed out to have the employer stock cashed out of the plan. And there were some other provisions in the settlement that the judge in the matter said, this is ERISA law. You need an attorney and a benefits attorney. Go back to the drawing board with the benefits attorney to advise you on how to write this settlement in a way that's compliant with ERISA, so you don't break any federal rules, with the settlement. And that was wise, because if they had been permitted to settle with the provisions as they were, they would have committed a prohibited transaction and a violation of probably the terms of the plan document as well. But what I helped them do, or what we helped them do, was avoid distribute. They wanted to distribute they wanted to treat the employee's rights as an employee separate from his benefit, and his benefit as one same thing. And you can't do that. When an employee has a benefit in a retirement plan, that benefit is paramount in treatment. It must be treated properly. And he was not permitted, this plaintiff was not permitted to, would not have been permitted to negotiate away his plan benefit for the sake of getting funds outside of his plan. So say he settles on, going back to my idea of having 8 claims that are employment law claims and 2 claims that are benefit claims. If he was willing to settle the 8 regular state law claims by giving up on his federal claims, he wouldn't be allowed to do that. He has to respect the company is forced in a settlement with a participant in a plan to honor the terms of the plan in settling this lawsuit. So they were not allowed to just ignore. All the parties wanted to just basically blow off the plan and give this fellow some cash as a settlement outside of the plan, and that would have been a prohibited transaction, and perhaps in violation of the terms of the plan document as well, which would just sit there as uncorrected. It would have happened. The transaction doesn't get stopped. It just sits there and is a prohibited transaction and continues to grow in penalties until it's identified and corrected. So the court was wise to send them to a benefits attorney, because I was able to prevent them doing that. And so that felt like, a win for them.
Yeah, I would also add that an example of sort of the opposite, a situation where we didn't get called into a situation and it led to a lot more, pain and suffering for the employer, because the employment attorney didn't understand that they needed to look at a benefits issue related to a big layoff. And it's like they did all the stuff that they needed to do, gave notices, did all these things, employment lawyers do very well to effectuate a layoff. But what happened was there were so many plan participants in the retirement plan who were laid off, and it was over a period. There was like a series of layoffs over a period of like a year and a half, and that they didn't do anything about that. And then this particular plan was subject to an independent audit each year, and it didn't get recognized until they got a new auditor who was really good and said, "Wait a minute, you had this big layoff. Is that a partial termination? And did you do like full vesting like you're required to?" Well, they hadn't even paid attention to it, and they did have a big partial termination. And so, it was a matter of having it. Then this created an issue of having to go back and find people who were long gone and give them money that they were owed under the retirement plan because of the partial termination. And, then that means the longer this kind of goes on, that means more interest. And if we'd been brought in at the time of the layoff, then, we could have handled this much more smoothly, when people's memories are fresh, when you know where people are in order to, give them notices or payments and things like that. So, I mean, that's something, there's probably many, many situations where that's been the case.
So, ladies, let's land the plane on this, because we've been talking about the difference between the employment lawyers, the employee benefits lawyers, the different examples. Dahl, I'll start with you, and Kathleen, you can chime in as well. What can employment lawyers who are listening to this right now, what can they do to identify some of these benefit plan issues that you guys mentioned early on? What are those examples, and how can they identify them early on in the case?
Well, it's in any sort of layoff situation or lawsuit, a benefits attorney or a employment attorney who's been brought in should, if they see the term benefit in any claim or in an issue, if there are benefits in the company, they should just be sensitive to the fact that there's a likely issue to be identified, to be resolved with the benefits attorney. So what they really should do is get to know benefits attorneys like us, and we cross refer, back and forth between firms that are employment firms and our firm that's employee benefits. We develop a networking relationship with benefits attorneys is what I would suggest that they do, and create the kind of just have a network of people that they know they can bounce things off of, raise issues, just get a little bit of education on spotting issues so that they know when to bring someone in. And I'm not sure, it depends on the size of the company, whether or not the company would even contact an employment attorney, in connection with these issues. I think they likely would in the case of a layoff. Usually the company is the target of a lawsuit. So they've been served in a lawsuit. And so they pick up the phone and call their employment attorney. If that's the time when, if a company is involved with an employment lawyer, that employment lawyer should always be sensitive to the whole scope of exposure for their client, including benefits.
Ladies, thank you so much for the time and insights on all this. We truly appreciate it.
Oh, thank
Thanks,
you.
Mike,
Thanks very
for
much,
having
Mike.
us.
Yeah. And thank you to everybody out there listening to another episode of Employee Benefit Plans and Business Sense. If you're an employment lawyer listening out there, you want to safeguard your clients from hidden benefit plan problems, do me a favor. Visit klblawgroup.com to connect with Dal and Kathleen. For everybody else, be sure to like, subscribe, review. Send this episode to somebody who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.